Okay, so hi everyone, it's Grant Abbott speaking, and thank you for welcoming to this session of the Moat. I have done this previously for our strategists and licensees and done a deep dive on the Moat. But today is just a very introductory session, and it's important that you come along on the 14th of October. We've got two elements there. One is I'll be going through and building the 3 or 4 case studies that apply for young people, older people and retirees, or for business people and then retirees, the 3 common characters in our client list. I'll take you through the Moat today, but there's going to be a few add-ons into the Moat a little bit later on. But suffice to say, this is what it's all about, is that the Moat is, if we have a look at our clients and we talk to our clients about building a Moat, essentially their castle is where all their family wealth is. You can see over here on the right-hand side, you've got a turret there. That may well be the family trust. We've got our little squiggly turret over here, which may well be our self-managed superannuation fund. We might have the inside being our property, our home. We might have a little one out there for our kids or a loan to the children. And the one there in the middle, we may well be our family protection trust. But essentially what we want to do is put a barrier around all those structures and make it really solid. So it's very difficult for the no-win, no-fee lawyers to really start to cross that barricade, to jump into the water and start to attack the family wealth castle. So to do that, we need to put in place a lot of structures. And the key area there for us is obviously litigation, not only from any bad characters, but also from the regulators, etc. Unfortunately, it doesn't work generally with a bankrupt. If someone's bankrupt already or about to go into insolvency, you're pretty well stuffed. But if you've got a client who's got a clean balance sheet, no issues, it's absolutely important to put a Moat together. And I'll talk a little bit more about that later on. For family provisions claims, it's absolutely crucial when we have a look at it. It's probably one of the big areas there is that you've seen me talk about this before. This was the Miller and Taylor case. You can see on the right-hand side, we've got a Supreme Court judge, Jeremy Courtois, launched a scathing attack on lawyers who'd feasted on a small family estate with their indefensible legal fees, described as a scandal, brings a profession in disrepute. That's straight out of the case. So it's not as if this is fake news or anything. So Justice Jeremy Courtois' withering takedown was aimed at the lawyers involved in the case of Angela Miller, who was the who was contesting the will of her late de facto partner, Andre Taylor, who left his entire estate, which was one property, had no mortgage on it, worth about $600,000 at the time, in October 2018, to his 2 adult children, Elizabeth and Philippe. And of course, they didn't want to give Angela Miller anything. So in a recent judgment, it was revealed that apart from the award, which was $240,000 to Angela Miller, the actual legal fees were more than $500,000 in a case involving 6 lawyers, one from interstate, but which only should have had 2 according to the judge. As he said, the small estate had been ravaged by legal fees. The costs in this matter are not, as counsel for the executor described, unfortunate. They are a scandal to the administration of justice and bring the legal profession into disrepute in the eyes of the public. So notwithstanding that, I mean, that's obviously probably a bit of an outlier case. But again, it just shows you the disgraceful situation that can occur. The main element there, though, is that it doesn't matter what you set up, whether it's testamentary trusts or anything, effectively, even in New South Wales SMSFs to a lesser extent, anything that you set up for your clients from estate planning or a lawyer that is sets up through their wills effectively can be challenged under the Family Provisions Act. This was obviously the Family Provisions section of the Succession Act in Western Australia, but every state has exactly the same claims, naming eligible persons such as spouses, de factos, children, even grandchildren to a certain extent, to make a claim on the estate if they felt they've been egregiously left out in one way, shape or form, or their award has not been significant enough for their liking. And of course, there's a lot of lawyers, particularly with the current COVID conditions out there, that are scouting for work. Now, I'm going to come back and we'll look at this case study a little bit later on, but I just wanted to preempt you here so I could take you through some of the structures that we're going to look at, and as I said, more importantly, on the day. So the moat, as you'll see, is like nothing else you will ever see in the world, and that's why it's a revolution in advising, because it brings about 10 strategies, and by the time I've finished with it, by the time we get around to October the 14th, there'll be at least 15 different strategies built into one interview process. So from your perspective as an advisor, it saves time, it saves resources. In fact, it saves at least 95% of the time of building all those 15 strategies for your clients. They're all compliant, they've all been signed off by Abbott-Mourly, and more importantly, they're all done in the appropriate compliance line. So for those of you who for those of you who are worried about compliance issues as a financial planner, they're all done exactly the same process. I'm more than happy to sit down with your compliance managers to take them through the moat. These are all documents you'll see when we get on there. They're all documents that are available already on the LightYear Docs site. But instead of just going and doing, for example, an enduring power of attorney here, an advanced healthcare directive there, a will and testamentary trust here, a deed upgrade for the SMSF to the leading member or the Royale SMSF up there, particularly now with 6 members about to pass, and how exciting is that one? Instead of trying to get those, put all the information, all it is, it's all done in a line. And the beautiful thing about that is if there's one small change, for example, the favoured daughter becomes one of who's in disrepute, then it's very easy to go into the moat and make changes quickly and effectively. And so what we're doing is we're keeping that water, that moat around the family's castle. If the daughter is ejected and wants to take action, then she's got to start to go around that moat, and it's a very difficult process. In addition, it also can, I'll show you how it protects on the day on October the 14th from family law claims as well. Anyway, let's have a look at Ken and Rose, who are both age 50. So this is going to be typically our midsection case study. We'll have ones for people who are aged 70 to 75 in terms of estate planning with SMSFs over T-bars. That'll be another case study. And then we're going to look at young families around 30 to 35. So we can position each of those different case studies, which will be available on the day on October the 14th. So make sure that you are there. So hopefully you're still getting me. Kerry Flood said that I might have dropped out. And again, this will be recorded. So I apologise if it's dropping in and out, but it looks as though it's okay to me. So please just let me know if I've dropped out. Just let me know on the chat line, which would be fantastic. So let's go through and have a look at Ken and Rose, age 50, who are equal shareholders and directors of Butchery Proprietary Limited, who are operating successful retail butcher's shop, which has been valued, thank you very much, Coffs Harbour, which has been valued recently for $2 million. They've got 2 adult children, Harry, who's in an 18-month relationship with Sally, an employed apprentice butcher, so that's Harry, not Sally. The other, William, single, who's in the army. William hates Sally and vice versa. So there's certainly conflict there. And if I see that, that's where I get worried when we start to use wills and testamentary trusts. For me, I go there. I'll show you a little bit later. That's where I look at the protector and, more importantly, look at essentially having nothing in the will if that is possible. They have a self-managed superannuation fund, which is the Rose Family Super Fund with $550,000 member benefits each. Ken and Rose aspire to purchase the shop they currently lease for $1.5 million. Ken and Rose have significant equity in their $1 million home with only a $200K mortgage. They both have old wills executed prior to the children being born, and their BDBN points everything into the estate. So potentially they'd be able to buy that with an LRBA through their home. So if you want to ask questions, along the way. Perhaps, Nathan, when I get around to filling in the documents, which might be a bit better solution. So when we go down the improved structuring, so typically we're going to have just a discretionary trust for a client, an ordinary SMSF, and potentially the wills and the executor. Now, going back to the Miller and Taylor case, we're trying to draw a line there and make sure that the estate is as low as possible. Everything is going over to see on the left-hand side, the Family Protection Trust, which has a leading member discretionary trustee, which can be the same one for the leading member discretionary trust. So here, because they're operating a business and we've got a bucket company there, then we make that, we'd upgrade that, the existing discretionary trust to a leading member discretionary trust. And likewise, the same with the SMSF as well. And perhaps establish, because we've got a business in there and they're butchers, we don't really want to effectively put any assets, or if we're doing the protector, which is a gift loan back strategy, we don't want to put the equity from their home, etc., into that business trust. We want to set up a separate family protection trust. And ideally, when they sell their business and their proceeds, effectively what we can do is we can restructure and make this, or just transfer everything over to the family protection trust. So some of the issues around us that we want to really focus in on, and particularly on the 14th of October, is essentially the idea of who is a dependent. I've been doing a bit of work with Chris Kasia, who's one of our latest advisors, and particularly around grandchildren and whether there are financial dependents. There's been some really good articles on this. We've got the cases of Malik versus the Federal Commissioner of Taxation. And you can see up there, where I've just extracted, which we'll certainly look at on the day, is from the legal database. This is from the Australian Taxation Office, the Commissioner of Taxation, and it's very recent. It was only in October 2019. And I haven't really seen it anywhere, but we've got the beneficiaries who are living with their parent, but they did not reside with the deceased. However, the deceased did provide financial support for them, including, as you can see there, regular payment of tertiary education course for the first beneficiary. And remember, they did not live with their parent, the parent or the deceased. So they lived with the parent, but they didn't live with the deceased. The second one, provision of supplementary income to the second beneficiary for living expenses, and the provision of supplementary income for the third beneficiary for living expenses. So it wasn't substantial. Essentially, these three elements, it was held that they were all effectively in a position of being dependents for superannuation purposes. So we want to lock that away. We've got a private binding ruling, which has been quite revolutionary from my perspective, but it enables that if we've got grandchildren, for example, with school fees, that's very commensurate with that first beneficiary that we've seen there. And in that instance, it means that a grandchild can effectively carry on a auto-reversionary beneficiary from the original pension beneficiary, a member. And so as an account-based pension, it would continue on. And if the original pension beneficiary, so in this case, obviously it couldn't be Ken, because he's aged over 50. But if, for example, it was John Smith, who's aged 61, and went from John to his wife to Sally, and then down to the grandchildren who are financially dependent at that time to be split equally, then effectively, if they meet these conditions, because John and also Sally have been paying for their school fees, etc., then it means that if John was in receipt of the pension, it was tax-free to John, tax-free to Sally, then it's also tax-free to the grandchildren. As opposed to an adult child, unfortunately, as a child, even if the child was a dependent, they wouldn't be able to carry on the pension post age 25. Grandchildren can, because they're not children of the deceased, but grandchildren can, as I said, because they're not children. So children, if they're over age 25, would have to take the money as a lump sum, not as a pension. Ordinarily, it would go into the estate, but remember, my motto is nothing in the estate. So what we would do is effectively, it can go out to the adult children, And if we go out to the adult children, we would put it out to an SMSF Death Benefits Trust, which is a leading member trust. So in that instance, it's a much better way of going. And you would be surprised, we can look after the grandchildren through that and also the children as well. And it is a testamentary trust for section 102 AG, but it's not subsection 2, it's 102 AG 4. And you might have seen there's been a lot of discussion around the traps around how testamentary trusts, in fact, I saw my good friend, my great colleague, Daniel Butler, suggesting that these days, if any superannuation goes into an estate, into a testamentary trust, it is important that you make sure that there's a private binding ruling, the executor receives one before even considering making any payout, which could take or delay the estate for 6 months to 12 months. Here, it's absolutely guaranteed. It's a section that's very often not used. In fact, when I first floated this, there was so many, it was funny, there was so many lawyers coming to me and saying this can't be done. It's simply that they've just never done it. The good thing about it is it's directly paid and the trust is created, get this, not by the executor of the estate, the trust is created by the trustee of the self-managed super fund. So you can see on the right-hand side, for those of you who have been reading while I've been having a chat there, you can see we've got Sally Smith, for example, the example I just talked about. If she was paid all of her superannuation interests, we've got there, this benefit may be paid as an income stream if allowed under super laws or transferred directly to the designated beneficiary or any trust, company, person or other entity the beneficiary directs, including a transfer to the deceased member's estate for the asset to be held specifically for the beneficiary or in a trust for that purpose. So it's pretty wide open. But at the direction of the beneficiary or any leading member, the trustee may create a SMSF Death Benefits Trust to hold a designated bequest. Now, if the adult child or the grandchildren, so we may want to, instead of having that reversionary pension, or we haven't had that option, we can pay it all into an SMSF Death Benefits Trust. Our grandchildren, irrespective of their age, effectively be taxed as ordinary marginal rate adult taxpayers. So that's a huge thumbs up. Importantly, from that perspective, remember how I said we've got auto reversionaries, particularly for grandchildren, but we may pay the money out to the adult children if they're over age 25 because they cannot take a pension due to section 621 section SIS regulation 621. Effectively, from that perspective, then what can happen is that money may be paid into a death benefits trust or SMSF Death Benefits Trust, and if they are dependent at that time, it will be tax-free. So even if they're older, they're tax-free. Go back and have a look at that private binding ruling, but I will do a further deep dive on that on October the 14th. The other one is our Family Protection Trust. So this is the same as our leading member trust. It's just got a different name. You can get it from our trust section of our website, but certainly it's not a bad idea. It's just a different way of talking to the client. But I do know that there's a lot of people who are using our leading member system. And the key thing there is about succession planning. Sorry about that. Looks as though I just dropped off, but I'm back now. So very apologies again. The internet is a little bit rubbish up here, but anyway, hopefully you can hear. Just if you can put your hand up or just give me on the chat that you can hear. We're back. Thank you very much. So apologies for that. Hopefully it won't happen again. The Family Protection Trust, the leading member trust, is succession proud. So in order to be strong, and this is absolutely essential for your clients, and I would strongly suggest that for all of you who've got clients with discretionary trusts, you may want to have a look at updating or upgrading to a family. So sorry about dropping in and out. Eric, what I'll do is, again, this will be recorded and will be out this afternoon. So the Family Protection Trust, essentially what we do is, at its heart, it's there for family protection. So we need, in order to strengthen or keep that moat alive, we need to ensure that we have really good succession, so that we have the first leading member, then the second leading member, then the third leading member. Because, for example, if we've got the first leading member, and I generally don't like having joint leading members at any point in time, certainly not the first one, but if the first one goes bankrupt, first leading member appointor, or becomes subject to a family law action, then we want to get rid of them as leading member appointor and also as trustee of the leading member discretionary trust. So it automatically goes down to the next leading member and they have no right or entitlement to that trust. So that's crucial. So again, we'll look at this a little bit later on, but this is available up on the site. If you actually change an existing discretionary trust to a leading member trust or a family protection trust, then effectively what we will see there is not a resettlement. In fact, the way we've set it up, we borrow the Commissioner's Tax Determination 2012/21 and follow that to the letter to make sure there is no resettlement and no capital gains tax issues. One of the key points again for both leading member and also the Family Protection Trust is that the only beneficiaries are the bloodline or the lineal descendants of the family protection appointor. So it's absolutely crucial that we use this tool for our clients. Now, the protector follows along from the case of Attia versus Nosbaum. We're getting into a position that it's a very popular strategy used by a lot of our advisors. And essentially, it's a gift loan back strategy. And essentially what happens there is we gift over, and I'll show you what it looks like. We have a accountant's solvency certificate. So this is all part of the automation of the protector, a deed of gift. So what we do is, for example, in a case, if we went back to, remember the Miller and the Taylor case, where there was obviously a fight between Angela Miller and also Andre Taylor's estate. If there was that property itself wasn't in the estate, but was in a family protection trust, because the Andre Taylor had gifted the $600,000 equity, not the property, the $600,000 equity into a family protection trust, then effectively that had been lent back to Andre Taylor. At the end of his days, there would be nothing in his estate. So unfortunately, if his children were the bloodline beneficiaries, then Angela Miller would be left out and wouldn't have an action under a family provisions claim, particularly in Western Australia. And we've got Tim there. He did 7 protectors last month, and I can't wait for Tim to come on and really smash out on the 14th of October. Just listening to Tim about how he uses the Moat, etc., and the protector is absolutely crucial, particularly if you're charging $4,000 to $5,000 per protector. It's an absolute no-brainer, and one that you should use for all of your clients. A couple of issues there is we're currently looking at getting on PEXA, which is a database that leads straight into all of the land titles offices across Australia, so that we'll be able to do electronic lodgement of mortgage documents. So it's still in its nascent days, but we'll be looking at that and also PPSR as well. As I said before, it doesn't protect from bankruptcy immediately, but it does protect against everything else. So it's a very exciting thing. And again, from Abbott Mourly, we've signed everything off, and I'll go through the 5-step process. So we'll look at that when we get down to October. So what I'm going to do is just going to bounce out of here. I'm going to have a look at the protector. So what I've got up here is I've got the LightYear docs. I'm just going to go in to the LightYear docs itself. And Tim, if you just want to tell people how much you how much you're normally charging, just put it on the chat line. That'd be great if you did that, and have a chat while everyone else is going. This is the great thing about the LightYear docs, our ecosystem, is everyone is not fighting against each other. We're all actually in a process of making sure that we're all doing the right thing. So I'm just going to go here. You see on the left-hand side, I'm going to go into my document storage. I've already loaded up the Rose Butchery one. I'm going to go into my vault. I'll go into the Abbott test, and then I'll talk about where we're at with I'll go in and talk about exactly where we're at in terms of the protector, and in terms of the moat and how we're building all together, and a couple of things that are coming out. So let's just go down. I'll find the one that I built. I did do this about a couple of months ago. So there's a couple of areas that we haven't looked at. So let me go down. So we want to go down the moat. There's the protector for the rose butcher. Hopefully I've got the moat. Oh, here we go. So you can see here the comprehensive estate planning package, the moat. Originally they didn't have the protector, so we're putting it all in. For those of you who are not aware, the beautiful thing about it, particularly for the strategists or licensees, you can go back and relaunch these documents at any time, which means if you need to go in and do a quick fix up, particularly if some circumstances changed, effectively you can do that really quickly in our system. So what I've done is I've loaded up the moat. This is the Rose Butchery, member Ken, and I'll just go through it. So this is the moat, the comprehensive estate planning package. I found it easily in my folder by naming it the KR Moat. I've given it the Abbott-Mourly tag because there's quite a few, in my instance, there's quite a few legal documents in here. So we want to obviously use the Abbott-Mourly. We've got the common parties here. So all I do is you can see with the common parties, we just put in there, we've got Ken Butcher. Well, I've just put Butcher instead of Rose. He's in Fairlight, New South Wales. So this should be 2095. And then we've got his, all I have to do is if I want one, I can just add another, but I've already done this beforehand. So I've got Ken and I've also got Rose there. I've got all the details there. We've got William. Remember William, who is the son who's in the army, and effectively we've got 2094, so that's okay. And then we've got Harry Butcher. He's in Manly. And then we've also got the business itself. So we've got Butcher Business, Pty Limited there as well. So we've got Ken Butcher. So when we do all that, we can effectively go through. Let's just go back to the slides so we can refresh our memory and know what we're dealing with. So we've got Ken and Rose are both age 50, equal shareholders, directors of butchery, and operating successful retail butcher shop, which has been valued recently for $2 million. So there's no loan on that. So the equity in the butcher shop is $2 million. They've got 2 adult children, Harry, who's working in their butcher, and then we've got William, as I said, who's single in the army. But Harry and, William hates Sally and Sally hates William. So we haven't put Sally into the common parties. Now, if they did have a friend, we could do that, and I will do that. They've got an SMSF that's got $550,000 in member benefits. Ken and Rose want to purchase the shop they currently lease for $1.5 million. And they've got plenty of equity in their $1 million home, so they could do a related party loan if they wanted to do that quite easily. So a back-to-back loan if we wanted to do that. But there's other ways. They've got wills that are very old and a BGBN that takes everything to the estate. So it's a pretty ugly looking scenario in terms of the moat. I mean, you can just see there's so many areas that can be challenged. So I've got it up here. You can see there, the next stage that we want to have a look at is effectively the documents that we're going to build. So what we've got there is I'm going to add the protector just to show you what it looks like. So I'm going to click on the protector. I'm going to protect that $2 million equity they have in their business. If I remember correctly, let me just go through. They haven't got a... Okay, so they haven't got a family trust for the business. It's just operating, so the directors are Butchery Proprietary Limited. So it's actually operating through a company itself, which obviously is of great concern. So what I'm going to do is I'm going to show you what we'll do with that. So let's go back, and we've got the protector. They're in New South Wales, so we want to tick an enduring power of attorney. At this stage, it's just a single moat for one person. We will be building an option to being able to doing enduring powers of attorney for spouses in here. But as you can see, it's quite a big set of documents as we're going through. When we go through the upgrade, we can set up a SMSF if we want to, but I'm not going to do that. What I'm going to do is they've already got an SMSF, so I'm going to do a constitution upgrade of the SMSF, and I'm going to also upgrade the SMSF trust deed with a leading member. I'm going to do an SMSF will, and then I'm going to do probably because I've done the protector, I'm only going to do the last will and testament because I don't want anything left inside the will. Now, as an accountant, we want to make sure that effectively we're signing off. And if I have a look, we'll do that from today's date, the 1st of October. And then what we'll do is we'll just make it change GPS. Oh, sorry. So change. Okay, we haven't got that there. So, oh, sorry, I've already put that down. You could have, if I wanted to, I could have put inside my, as you can see up on the left, I could have put in my common parties the name of the accounting firm, and then that would have popped up here. But what I've done is I haven't done that, so it's just come up as super accounts. So that's it. So I'm doing all of those documents. So the first one we go to is the enduring power of attorney. So all I have to do is I go through the process, and I'll take you through quickly. Again, we'll spend a lot more time on this on the 14th of October, but I wanted to give you a really good flow of this. This is like an intro. I would strongly suggest that a lot of you are on here, particularly if you're licensees, build your own moat between now and then. And I know, Nathan Chapman, you've been doing it, and you've come back with some great suggestions on it, how we can fix it up. So with the principal, we've got Ken Butcher in there. Unfortunately, as I said before, because of the sheer volume of the documents and the size, if I did all this and printed it out, essentially what we've got is around 180 pages. Because in the document setup, what I need to do, I need to use this as the Moat version 101. What I have to build in here is advanced healthcare directives. Also enduring guardianships as well. I also need to build in here, and we've got it all there, a upgrade of the discretionary trust to a leading member discretionary trust for a business, and exactly the same for any corporate trustee. Plus, I have to do a couple of things around family allowance agreements. Remember we talked about that discretionary trust? I want to build that all into this site. So there's about another 7 to 10 documents going in there. So you can start to see this is virtually a one-stop shop for all your client advising. Again, it's a one-stop shop for all your client advising. Because of the size of it, I haven't put in that second principle, the ability to add rows in there at a later stage. I will get there, but I want to get the big volume in first. I want to get everything in there because I know, Tim, you're waiting on the big one. So I can put in the principle. I've done Ken. In the meantime, if you want to obviously look after Rose, you can do her through the will and EPOA side of things if you want, because a lot of the other stuff is already catered for here. So in the attorney, I've got 2 here. All I've done is I've gone and chosen Rose and also Harry, because we can just go through the common parties. Let's say that we don't want, you know, the boys are fighting. So I'm going to go down here and I'm going to put in the best mate, who's going to come in and look after it. So I'm going to add another one here. I'm going to put in an individual. We've got here Jeff Jones, and Jeff is at 5 Jones, oh sorry, typing's not the best up here, 5 Jones Street, Sydney, New South Wales, 2000. So what I can do here is you can see I've added that. That's now come up into my my common parties, and I'll go down to the attorney here, and I've got Rose in there. Let's go down to Harry. Now we know that Harry and potentially Harry's wife's going to fight with Sally. So why don't we put Jeff Jones in there? So you can see how easy it is. I can go in and meld and make this as I see fit, because essentially going to send this out to the client, and the client's then going to come back with a whole lot of decision making. Now the replacement attorney, do you want to appoint a replacement attorney if Jeff and Rose aren't there? I'll go yes. Is it going to be succeeding? Yes. And then what I would do there, I would then put Harry Butcher, and I just go tab there and then put William Butcher. I think I'm going to have to make sure I'll go back and change this system so we can, instead of having to put this in here, because you can see with the common parties for Harry, I've got to go down and do a copy and paste, which is painful. So I don't want to do that. So again, this is one of the areas that we need to address there. And so that's Manly, New South Wales 2094. And then William was, if I remember, if I just go up a bit and then get William. As I said before, we'll make sure that we have this auto placed in here. So I go down to the replacement attorneys. Again, I didn't have this in the system, but it shows just how easy it is to look after 2094. Okay, so do I want, I've got those, so I've got plenty of attorneys in there now, so I don't need any more. So I'm going to go no, I don't need an alternative. So the power of attorney, we've got quite a lot of elements here. So first off, do we want them to act as a replacement trustee or a replacement director? So really good question. Is that many documents effectively too daunting for clients? Absolutely. I've done a separate session on this. Essentially what you'll do is you'll have all the documents, but what I'd strongly suggest is you would, for example, send out the EPOA to the client and then just say, we must get this back within 3 days, because then we'll send the will out to you. And then just keep it on a 3 or a 4 day, 5 day timeline so that you don't give it all to the documents, otherwise it is too daunting. So you just keep on feeding it through to them. So with the attorney, we want to make sure we're acting on behalf. We want to do everything an attorney can do, which is traditional, and also act as a successor director. Remember, we've got Butcher there. So Butcher Proprietary Limited, we want to make sure they act as successor director. We've got a choice here. When do we want to sign? I'd go straight away upon signing of the document. Do you want to revoke previous attorneys? Remember, this is New South Wales. I'll go yes. And then you can get Tony Animalis to sign off on this. Now, again, you're going to get Tony to sign off on the SMSF will, the EPOA, and the will and testamentary trust anyway. So it's all wrapped up. And remember, just for the Rose, or for Rose Butcher, for Ken Butcher here, effectively it would be classified as just $4.95 for that sign off. So again, we've got a few extra little buttons. So I authorise my attorney to give reasonable gifts, state additional powers of attorney, so on and so forth. Let's go down to the next one. Remember, we had successor directors. So I've got business butchers there, effectively got the ACN. We've got Ken and Rose, who are the current directors' names. And of course, if something happens to Ken, then obviously Rose is there, but Jeff Jones can also be appointed as a successor director. So that effectively is our EPOA. Let's just go down to the SMSF. Has anyone got any questions from that so far? So it doesn't, we don't have any email addresses in there, but that's a good point. If you think that's a good idea to put email addresses in there, then absolutely we can put email addresses in there into the documents. So again, the good thing about our system is that we like to get feedback from you. So please give us feedback on the way through, or importantly, if you want to send us an email afterwards, and then what we can do to add that. So I will have a look at adding emails for that. We've just got a couple of more things to do. So we've got the Butcher Family Superannuation Fund. We're doing the deed upgrade. At this stage, I don't have the company there for Ken and Rose there. So I can go through and I can add another company here. So all I do is add another one there. and then I've got a company. So we'll just call it Rose Ken Nominees, Pty Limited. We've got, well, put in the ACN, put in the address, 5 Smith Street, Manly, or wherever your addresses are for the registered office, 2095 or 2094, sorry. And then we've got 2 directors. So what we can do, in fact, if we want, we could remember enduring powers of attorney. We could effectively if we've got an enduring power of attorney, the person doesn't need to be a director of the superannuation fund trustee company. So we've got Ken and Rose Butcher. So I click on both of those. So that's been added to the system. So I'm going to go through. I've got a special purpose corporate trustee. So what I do now is I've already put that party in there. I just go into Rose Nominees. That goes through, and now obviously I've got a constitution now. So we've upgraded that to a special purpose corporate trustee. Now I've got the shareholder's name. So let's put if all the shares, and it should be for a leading member, all the shares are owned by Ken Butcher, chairperson. So we've got, go through there, we've got Ken Butcher. So that's for the meeting. Leading member. So is there a joint leading member? No. So who's going to be the leading member? Ken. So we're just going through. Is there a second leading member? Yes. Let's go through. And in this instance, I'm going to make that Rose. It just shows you how easy it is. Is there a third leading member? Yes. And this one, because it's mainly business, I'm going to make this Harry. So that might put William out of thing. I could have always, if I wanted to, I could have made it joint, but I've just done it that way. So I'm upgrading the SMSF trustee company. So it's going to apply in New South Wales. So when are we going to change it? So I'm going to change it from the 1st of October. When was the fund originally set up? So you guys just go to your permanent file, have a look at that, 09, 2012. So it's pretty old anyway. Has it been varied again in the past? We go no. Again, remember, this is going to come out to you as a recording. What's the rule number to change the deed? We'll say 41. Does the trust deed variation clause require someone else to sign off? And we go no there. Okay, so now I've done the EPOA for them. I've also effectively done for them as well the upgrade of their client deed. So we've already done the deed of upgrade. We've also changed the constitution. Now we're getting into the SMSF will. Remember, I did that before. So effectively, we don't know the date of application. The first thing is going to be for Ken. You can see how easy it is. I could actually do it. And at some point in time, we could actually do it for Rose and just put it in there. But again, we just want to make sure you get your head. You really need to be on top of this altogether. Always go down the 6 buttons. You'll see there's 6 different clauses. Always go yes there. Reversionary to pensions take precedence. If you've gone in your EPOA, you want the executor as a replacement trustee, I'd put that in there. Now, the death benefit payments, we've got here, Rose Butcher, the spouse. All interests of my superannuations have in the butcher shop. So what I'm doing is I would have done an LRBA shop for that and essentially would have put that in there. Is there a succeeding beneficiary? And so this is a new change to our will. So our SMSF will. So I've got Harry Butcher is the succeeding beneficiary. So we're going to look after William elsewhere. So Harry Butcher, now if Harry's not alive, then what's going to happen? Then we paste it, we can either put it into the estate for the deceased bloodline and effectively carry on from there, or through an SMSF Death Benefits Trust if allowed. So it goes from Rose, and if she's not alive, it goes to Harry. He's not alive, it then goes to his estate, or if the trustee is around, it can set up a death benefit trust for Harry and his children. But again, of course, Harry would have to be deceased. And I can can effectively add another if I want to effectively go down and do that. So what I've got there is I've got William Smith. So I have added a separate one. So any other interest that hasn't been passed to Sal, so it hasn't been passed to Rose, would go to William. Is there a succeeding beneficiary? Yes. Well, if William's not alive, as you can see, we've put there Harry Smith is to effectively take control. And then if Harry's not alive, it goes down to his estate. So again, it's presuming there he's got children or bloodline there. A worst case scenario, if no one's around, then it does go to his wife. The nominated professional is the super accountants. So we put those people in there. So I've got John Accountant. And then that's where the administration comes in. So it's a very important tool to make sure that you're the administrator. The meeting date I put in there is obviously just Ken and Ken. We've had the meeting for it, but again, I could have made that a bigger one. Last will and testament. We go down to the general. We've got the testator. Remember, I'm going to do a protector. So this is just a really, I've got there, I think, last will and testament. So I've only just done a basic one there, not a testamentary trust. We've got Ken there. And again, you put your details down there as the professional advisor to the estate. Absolutely crucial. The executor I've got there is Rose and Harry. I'm actually going to switch out Harry and put in... I'm going to put in Jeff Jones. So we've got there Rose, who's a spouse, Jeff Jones, who's a colleague. And again, you could do it, but probably not. Successor executor, I've got William. I'm going to put in there William and also Harry now because Harry was in there. So they're now the executors. Second successor, I've got no, because really there's no one else around from that. Binding vote. Okay, so I've got Rose there. It's got the binding vote. Now, William versus Harry. I'm going to choose William because remember, Harry took a lot out of the SMSF. So let's make William the binding vote there. Principal beneficiary is Rose. How much is she to get? She's going to get 100% of my estate. Now, if she's not alive, then it's going to be paid to the secondary beneficiary. So you've got 4 choices here that you can make. So it can either go to her bloodline children to be held on trust. That's mainly for minors, to any surviving principal beneficiary. But as she's got 100% of the estate, you don't need that. Paid to the secondary beneficiary. The secondary beneficiary in this instance was Harry Butcher. But effectively, because we're going to do a family protection trust, what I'm going to make that is William there. And how much of the estate will be allocated, and I'm going to go 100%. Remember, because I'm looking after Harry through the SMSF and the Family Protection Trust. So 100% of my estate. So I said, have a go at yourself. Is there a tertiary beneficiary? Then what I'm going to do there is I'm going to make that now Harry Butcher there. So tertiary is if both Rose is dead and William is dead as well. So again, 100% of the estate. As you can see, 100%. As you can see, effectively remaining estate. As you can see, what I've done there is effectively, if there's no one around, then it just goes to bloodline beneficiaries. Specific gifts, I've got, yes, I've chosen the estate is to pay the specific gifts. There's no testamentary trust here. Rose is to get all the shares in Butcher business, which is important. So I'm going to go no there. Goes to Rose. She's a female. She's a spouse. She gets all the shares in the Butcher business. So that's okay. Digital assets, obviously they're just Butchers. We won't worry about cryptocurrency and digital assets there. Child guardianship, we've got no already. Pet guardianship, I've got no. Funeral wishes, scattered off the beach at Manor, New South Wales at sunrise on my birthday, so that's fine. So then we go down to the final one is the protector. So would you like to establish a trust? I'm going to go yes, and then I'm going to do a solvency certificate, a deed of gift, a promissory note, a loan agreement, mortgage deed. I'm not going to do a personal guarantee. So let's see what we've got there. So when we go down, and I've got a question here from Nathan, for primary secondary beneficiary, is there reason only people and not companies from the common party section can be set as beneficiaries? Yeah, that's a really good question, Nathan. There is no reason. It's just that no one's come back to us and suggested that. So let me take that on board. If you want to just put that question in an email so I can then go back to our developers and we'll add that next week. Is it possible to add an option to choose a protected trust instead of a testamentary trust within the primary, secondary beneficiaries or sections? Now, essentially what we've got there, we choose a family protection trust is essentially a testamentary trust. So when we choose a testamentary trust, we're choosing it for the benefit of our beneficiaries. So on death, you'll see if you have a look at our documents that are produced, which I won't have time to show you today. I just want to show you the setup of it. In fact, I'll do a quick whiz through. But essentially what will happen there is the testamentary trust has all the T's and C's involved with it, including successors. You saw all the relevant issues there. So the testamentary trust can be a family protected trust. So it would be created by the executor at that time, but because it's a trust that's created under the will, it is a testamentary trust. So it meets both criteria there. So that's a fairly important, and it's an important question. Can the professional advisor be the corporate authorised rep? Absolutely. So it doesn't make any difference. I've put in just the accounting firm, but it should actually be the corporate authorised rep as well. Again, there's some really good monies to be made on that, but I mean, that's not an issue, but seeing you've set the whole thing up, you want to make sure it happens. So this is, since I did the last session, I didn't have the, so let me just go to the Smith Family Protection Trust. We didn't have this option in the Moat, so it's a new one, so it's an exciting one. When will the trust be established? The 1st of October, so I'm New South Wales. In fact, what I might do, I might actually just make it in South Australia. So wherever you nominate, then it follows those rules. South Australia, there's no rules against perpetuities, which is, so it really doesn't matter here. I mean, obviously this rule applies where it's vesting. So the set law, what we'll do is we'll get Jeff Jones to settle it. Oh, sorry, not Harry Butcher. It's my big thick thumb. Sorry about that one. So we've got Jeff Jones to settle it because he doesn't have an interest in the Family Protection Trust. He's going to settle it with $10. The trustee of the fund, I'm going to use a company, and I'm going to use, just for the sake of this, I'm going to use Rose and Ken nominees. Please note that was for the superannuation fund. It's just that I haven't got that extra common party in there. So please note, I would actually set up a common party, but I'm just running short of time. Leading member Appointor, absolutely yes. So it's going to be an individual, and who's it going to be? Is going to be Ken Butcher. So that's okay. Second leading member, I'm going to go yes. Is it joint? No. Who's it going to be? I'm going to make it Rose. And then is there a third one? Yes. Do that. Put that up. Is it joint? Yes. Actually, I'm going to go no, because otherwise I'm going to have to type those in again. I'm going to need to go back and fix that up so we can just make it as easy as pie as choosing it before. So we just go down there, potential beneficiaries. Does the leading member want their spouse to be a beneficiary? I would go yes in this instance. That would bring in, because remember the leading member is Ken. Rose wouldn't actually be a beneficiary because she's not bloodline of Ken. Any of the primary beneficiaries a company? I would go yes. Are any of the primary beneficiaries and incorporate? In fact, I'll go no there. And then I go no there as well. So the accountant, I've got there. I'm just going to choose, I haven't got my accountant's name. Again, I should have put that in there. So I'm just going to put Steve. In fact, what I should do is I'll go back and get the, sorry about mucking around. Let's get the administrator here. So the testator, and I'll just put super accountants here. You can see I should have put that in the professional advisor area. but I haven't done that. So naughty me. So the accountant, we're just going to go there. Firm name, super accountants. We're going to put Steve, accountant. And again, you can see you can save all this time. 5 Smith Street, Sydney, New South Wales, and that's 2000. Okay, so now the gifter. So what we've got there is the individual, because it's Ken and also Rose. So we've got Ken, and they're going to do it jointly, so I'm going to add another. So I've got Rose there. She goes there, and effectively that's all I'm going to do. So the giftee is our trust, and that should be our, the Rose Family Protection Trust. It's going to be a company, and then we've got the Rose Ken nominees. Again, as I said, remember, I'd have to put that in, but I'm just running against time, so apologies for that. The gift itself, so I've got at the moment, I'm not going to transfer the shares, so I'm going to do it the 1st of October. We're going to set this up in South Australia, as we said before. I've already set it up, but it should come in. So what I'm going to do is effectively cash, and that's going to be effectively $2,800,000, which effectively of promissory note. How did I get the 2,800,000? There was 2 million equity in their family home. In the business. So it's the actual shares. So I'm going to do a PPSR over the shares in Butcher Proprietary Limited, and also the $800,000 in the property. That's if I haven't chosen to do an LRBA. So we just go there. The next one is the promissor, is obviously going to be Ken, and again we're going to add another individual, which is going to be a Rose. So that's okay. So they're going to be, now the promisee is going to be the trust again. So the Rose Family Protection Trust. Now again, you can see it's quite, there's a lot of work, but it's also a lot of documents you're going to get here. But it's pretty easy. And again, any shortcuts you guys see, please let me know, because we want to make it as best as possible. So where's it going to be executed? We'll have it executed in New South Wales. And then the deed of promissory note is the 1st. What's the repayment date? 20 years or on the death of the note holders. So I'm going to be about another 10 minutes if you can hang around for that one. It's not going to be long. So the promise details, how much are they going to pay? Remember, it was 2,800. I'll just put in $10,000 as a compensation payment. Yes. So that's akin to interest. Is there a late payment fee? No. So then we go down to the lender. That's easy. The lender is the trustee of a trust. So again, it's the Rose Family Protection Trust. And again, we know the company. We'll just put that in. And we keep on going down. So the borrower there is obviously going to be the 2 individuals. So we've got Ken. So I have to choose Ken Butcher and add another, and that's going to be a Rose Butcher. So I've got all of that detail in there. The final one is the loan agreement. So let's do that. Today's date of commencement of the loan. Let's do today's date. Where's the loan agreement? New South Wales. We're going to make it a fixed loan. Principal amount is for 2,800,000, and then it's going to be for 20 years. and the commencement interest rate, it really doesn't matter. So just go 0.1% or whatever that correlates with that promissory note. Interest only, repayment, repayable at the end of the loan only, date of the mortgage deed, first of there. Real estate, we've obviously got their property in there. Other assets are going to be shares in Butcher, Pty, Butcher Pty Limited, I think it's Butcher Business. So that would be a PPSR registration. And you can start to see as I'm putting all this stuff in, there's no need, there won't be anything else out there. Oh, sorry, that's the loan, the real estate property. So I have to put in the property. So I need to put in the folio number, LF45. Okay, so that could be lot 501 Smith Street, Manly. So I'll just put that in, then it's 5, I forget what the address is, Smith Street. And effectively, I think we're almost there now. New South Wales 2000. So that's the last, if I remember correctly. So that is the final thing. So let's go next and let's go to finish. So you can see I'm using Chrome. If you're having problems with Chrome and a timeout, then just go, there's a quick fix for it. It's because Chrome obviously changed its cookies, or Google changed its cookies. It did so to stuff up Facebook anyway. So I've only got 5 minutes. I'm going to show you quickly through this. But again, I'll be building all of this on the day. I would strongly suggest that you build this for yourself. You can see it is a huge area for the clients. But effectively what we want to do is we want to make sure that with this system, so we've got the Moat, the Comprehensive Estate Planning Package, EPOA, SMSF Constitution upgrade the SMSF deed, SMSF will, last will and testament, the protector. As I said, to come, Advanced Healthcare Directive, enduring guardianship where it's required, for example, in Western Australia, in New South Wales and in Victoria, not like Queensland or South Australia. We're also going to have in there trust, so you'll be able to upgrade the trust deed of your family trust to a leading member of Family Protection Trust. You can already do a Family Protection Trust, obviously, through the protector. So there's still a bit of work in there. But again, this is very daunting for the clients. You've got your sign-off letter from Abbott-Mourly saying that you've built the whole system. You can see super accounts here. You built the whole system from the data capture of the client. If you want to know how I do it, I'll send you out a link to a session I did on how to effectively do this easily. So we've got, this is basically for the enduring power of attorney and also the will. We've got an execution letter there from Tony Anamoulis in terms of the will. And then we go into the EPOA, the enduring power of attorney. So we've got the enduring power of attorney there. You can see there, remember the attorneys appointed jointly and severally. We've got Jeff Jones and also Rose. You've got there, they can act on behalf of the superannuation fund and also as the successor director. So they'll go in, then you've got substitute attorneys. We sign off through there, acceptance by the attorneys and also substitute attorneys. So William and Harry will have to sign off there as well. Now we then go in and we produce, this is quite separate, a separate binding resolution by the company. And in this one we did Butcher to appoint a successor director. So the event that something happens to Ken, whether he dies or that effectively he loses his marble, loses his capacity or goes bankrupt, then Rose Butcher and Jeff Jones can be his successor director. But if Rose is already there, then it's not an issue. So we get that signed off by the two parties, Ken and Rose, and that's it. Then we get the constitution upgrade to a leading member. Remember I did that. This is actual constitution. I'll rip through that really quickly. Oh, sorry, then we go down. We've gone through there. So then we've got the leading member SMSF deed. So we're varying the current super fund deed to a leading member deed. We've got all the leading members, so on and so forth. Then we go down from there as you can see, we then go down to the SMSF will. And you're quite right, we can't send them out, but we send each of these out in a draft version, so you can cut them all up into separate documents, and then just, particularly if you've got a PDF, make sure you have a PDF document reader, cut them up in different ones and send them off to the client with a draft stamp and tell them it has to be back in 3 days because the next ones are coming through. So here's the application by Ken to do an SMSF will. I've just gone through the PDS, and you can see there, remember it's got that form that we had before. Death benefits of the fund goes to Rose, and then she's got all those titles. Remember, we saw that in the slides as well. Then we go down and we have a look at, obviously, the will and testamentary trust, so the binding resolution to accept the SMSF will, last will and testament. But remember, there's not going to be that much there because everything is already gifted over into the family protection trust. So we've got the will and testament, we got there, so that's that one done. Next one we've got there is executed by the testator and the executor. We've got the protector here. So we've got the establishment of the family protection trust deed. We then go into, as you can see, there's a lot there, and we've got more documents to come out of this. But the good thing about it is it's all in one interview form. So if we need to make a change, for example, if Harry turns out to be a bad boy and leaves with Sally, then what we can do is we can go and make some pretty quick changes. So we've got the protector there, the family protection trust, your solvency certificate, you must get an account, your deed of gift, and it just keeps on going down. Mortgage deeds, you've got a whole, you've got basically everything on the mortgage deed. If I go back, you'll see the mortgage deed effectively is going to be over, you can see there the property of Smith Street and the shares and butcher business. So we've got everything there all in one element. It takes a while to actually get on top of everything, but it's absolutely crucial. So if you have a look, so testamentary trust with EPO, the page personal health benefit exists, which doesn't exist in the moment. Can this be it? So Nathan, if that's Queensland, let me have a look at that after that one as well to get the personal health matters. Yeah, so David, definitely send those documents. But here's a question to you. If you went and wanted all those documents done with a lawyer, a local lawyer, how long would it take to get back and how long would it be done? My estimate is going to be 6 weeks, possibly up to 6 months, if not more, and how much would they charge? Here, we're putting everything in one line to make it easy for you, and you can see it's all done in exactly the right shape and form and the compliance there for you. Anyway, what I'd strongly suggest now is go back, do the Moat for yourself. I know Nathan Chapman, who's not an advisor, has done one for himself. He's done a damn good job at it, and congrats to you, Nathan, for that. We're going to be looking at it in a lot more detail we're going to look at a lot more detail on October the 14th. Make sure you get all your staff. And honestly, once I add those extra documents to it, you can see this is a one-stop advising shop for a client when it comes around to be succession, estate planning, and also the asset protection. And Nathan, actually probably will take up your time to actually be the case study on the day for October the 14th. So that'd be great. So we're 2 weeks away. It's October. At that session, we'll also be talking about, we've set up a not-for-profit public company, essentially being the Succession Asset Protection and Estate Planning Advisors Association. So that will be up and running, and I'll take you through that on the day and hopefully get a lot of people in there. And again, Tim Munro's come back and suggested between $4,000 to $6,000 he just charges for the protector. What you would charge for the whole Moat will be interesting, and it'll be great to see Tim's app on the day. Anyway, it's Grant Abbott up here at Port Douglas. Thank you. I'm sitting here sweating my little tush off, but thank you very much for attending today. And also thank you guys for sharing everything together, because we're all in this together. This is a revolution for advising, and that's essentially for us. That's where we are. It's Grant Abbott signing off.